Good evening, welcome. I'm Terry McCarthy. I'm President of the American Academy here in Berlin. Delighted you could join us tonight for our Lloyd Cutler lecture, which was very kindly endowed by the law firm here of WilmerHale and supported by them and also by some of their partners, including one who's here with us tonight, Ulrich Quack, who is sitting right here. Thank you for that support. We're very grateful to everyone who's helped make that possible. Our speaker tonight, Roberta Cooper Ramo, is one of the leading legal authorities in our country, I will say without any embarrassment. She's a partner of the New Mexico law firm of Modral and Sperling, but she's also the former president, and I think this is pretty rare, former president of both the American Bar Association and the president of the American Law Institute. And so she's going to talk tonight about how our legal system will help us to maintain our democratic system, which has some relevance to even what's happening right now as we speak. Roberta, the floor is yours.
Thank you, Terry. So, first of all, for all of the Americans in the audience, I thank you for separating yourself from the television set. My husband is here only under duress, I will tell you. Although it's also often iffy for me to speak in front of him. I was thinking as he sat there, he's a wonderful cardiologist and a great feminist in all ways. But having spent so many years on call, he often falls asleep the minute he sits down. And I was thinking tonight, actually, sweetheart, of the time I introduced the Dalai Lama. First of all, he almost ruined me because I agonized for weeks. How do you introduce the Dalai Lama? And he said, it's very simple. You sing, hello, Dalai. Well, hello. Well, the problem is, of course, you get that in your brain, and there's the Dalai Lama, and every part of me is fighting not to sing hello, Dalai. So there we go. Terry, I want to thank you and the Academy for such a gracious welcome in every way, and a special thank you to Dr. Barrett Ebert, who has taken care of us, rescued us from wrong train platforms, helped me with IT today, told me that it was okay to talk to you for 3 hours. I hope that's that's quite all right, and we appreciate this. I should say also, as I said to the partners at WilmerHale yesterday, I'm a huge admirer of that law firm. Many of the most important lawyers and best lawyers in every way in America are associated with the law firm, and I actually knew Lloyd Cutler, who was a quite amazing man in every way. He was on a little commission that I had to try to work with Chinese lawyers many, many years ago, he and Justice Kennedy. And Justice Kennedy, who's a brilliant guy, would have these global, wonderful, philosophic things that we should do, and Lloyd would actually figure out how the hell we were going to do that. So he was a big hero to me. Let me just say that it wouldn't surprise me to find that many of you are sitting there wondering why the Academy has followed justices of the United States Supreme Court, Pulitzer Prize-winning reporters for the New York Times, and scholars from the finest law schools in America with me. I have wondered that myself. I am neither a scholar, a journalist, nor a powerful judge. But in truth, I'm here because of Gerhard Casper's power of persuasion, I know. What I am is a kind of country lawyer with a clear view of what obligations American lawyers have in return for the privilege of practicing law. I didn't grow up wanting to be a lawyer. In fact, no one in my family had ever gone to law school. I had never been in a courtroom until I entered the University of Chicago Law School. I went to law school because I wanted to be a president of a university, which at the time for a woman seemed completely insane. And I thought, well, maybe if I had a decent career as a lawyer, there would be an opportunity for me to do something in the academy. I entered law school at a time when all around the United States, lawyers were working miracles. In the civil rights struggle of the 1960s, when issues of free speech were debated and litigated as the anti-Vietnam War protests took to the streets and to the courtroom. And I think it was the first time that I really heard the word feminist and understood its meaning. The idea of true equal rights for women was finding a voice and the words to express both the discrimination against women and the impact of that inequality. Against that background, I found myself wanting, as I began law school, to be a real lawyer, whatever that meant. And I enlisted in what I thought then and believe now was the profession that both established the American democracy and served as foot soldiers to protect it. In the face of this upheaval over 50 years ago, with all of the terrible things that were going on in my country, I never feared for the United States as a democracy. When we set this date a year ago, I didn't realize it was Election Day in the U.S. Today is the most consequential election of my very long life. As we sit here in Berlin, my fellow citizens are voting all across the United States for governors, for state legislators, quite importantly, for attorney generals of many states, for secretaries of state, and for what I'm sure you in Germany all know well, and that is the control of the United States Congress. Particularly after the horrendous and heartbreaking events of 2 weeks ago in the anti-Semitic slaughter of 11 Jews in a Pittsburgh synagogue, and the attempted murder of a past president, Secretary of State, a prominent Jewish philanthropist, 2 African-American members of Congress, members of the press, a U.S. Attorney General, a former one who is also African-American, and many others, my focus on the obligation of American lawyers to protect the Constitution and its important amendments has gained a certain clarity and much urgency from the time months ago when I gave this topic to the Academy. I want to make the case that each and every American lawyer who has taken the oath to protect and defend the Constitution must now act in his or her individual capacity to do just that. Because now I have some fear for my country's democracy. The current President of the United States, it does choke me up. Regularly attacks and demeans the independence of judges, lawyers, including those in his own Justice Department. A president who seems totally ignorant of the meaning of the oath of office that he took. And as of just a few days ago, he raised the possibility that he could somehow undo the 14th Amendment with a stroke of his pen. Benjamin Franklin and Tocqueville, who I mentioned when I first began thinking about this to the people at the Academy, are right on my point today. At the end of the Constitutional Convention, Franklin remarked, and actually this is often misquoted, "We have given them a republic, and now we shall see if they can keep it." Note, it's not a pure democracy that was created, in which a mere majority could run roughshod over the rights of individuals, but a republic in which the promises of the Declaration of Independence would be protected. We hold these truths to be self-evident, that all men are created equal, that they are endowed with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. The preamble to the Constitution echoes those thoughts. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Forgive me for repeating those words, which many of you know well, but which tragically some of my own fellow citizens, I fear the current president and some political leaders, either do not or ignore. And these are, as a nation, our first principles. Tonight, I want to celebrate both the history of American lawyers and the streak of stubborn independence and adherence to their oath of office that has sent thousands into action in various important ways over our country's history, and fortunately, in contemporary American society as well. As for most people, no matter their role or their society, my worldview has been influenced by where and how I grew up. the times I have lived through, and has bolstered my belief in the keystone role of American lawyers as first architects and now again foot soldiers in protection of the American system that relies on independent judges and independent lawyers who are to uphold the U.S. Constitution and are constrained by this same very slender document. The preamble and the Constitution as drafted were not enough for all of the 13 colonies to ratify them, because the individual rights that these colonists had fought, suffered, and died for were not clearly enumerated as far as they were concerned. From the tyranny of the majority, they insisted that something be very clearly said before they would vote to ratify the Constitution. The first 10 amendments, which you may know as the Bill of Rights, were ratified with the Constitution at the very same time, finally in December of 1791. Tocqueville, who those of you who are historians of any kind will know was a regular visitor to the United States and wrote a great deal about it, was concerned that mob rule of some sort might happen in the new American constitutional democracy. But he thought that there were some protections, and one of the key protections that he mentioned was the legal profession. In Democracy in America, Tocqueville wrote, "When one visits Americans and when one studies their law, one sees that the authority they have given to lawyers and the influence they have allowed them to have in the government form the most powerful barrier today against the lapses of democracy." Elsewhere, and I know there are historians among you, people who know Tocqueville and Franklin well will note that neither was a particular fan of individual lawyers. In fact, I think Franklin once said, "A countryman between two lawyers is like a fish between two cats." In a compact with the devil, in order to gain the votes of the Southern colonies, neither the Constitution nor the Bill of Rights outlawed slavery, nor did they heed Abigail Adams' written instruction to her husband not to forget the ladies. After the adoption of these amendments, we had an ongoing campaign and work by lawyers. It took a civil war, in fact, to adopt the amendments that were necessary to outlaw slavery and to deal with the issues involving persistent racism in our society. And that wasn't enough. It was the Southern president, Lyndon Baines Johnson, who got the Congress to pass a variety of civil rights legislation addressing racism, which gave civil rights lawyers the laws that they could litigate in addition to constitutional issues to work to make racial equality a reality in the United States. The challenge and honor of speaking to you today has offered me a chance to organize my thoughts about the brief I believe American lawyers, well-known, powerful, and not, must carry going forward. To be fair, which after all is a requirement for any judge, which I'm not, but I think for any lawyer as well, you probably need to know my own political views and some personal things so that you can weigh the value of my rendering of history and my prescription for American lawyers and judges from tomorrow morning, whatever happens, understanding what my personal biases are. First, I live in a very different place than Berlin or any metropolitan American society. And I thought I actually had to show you a picture of Albuquerque, which is where I live, so you could understand the place in which I grew up, raised my children, and practice today. The light of New Mexico allows for very little about you to be hidden as it hits you in the ambrosial mountain air. Whatever your flaws, they come through right to the surface. Whatever your strengths, become a shield that deflects the harmful ray of the sun while preserving the precious light. There is sky everywhere that clarifies the small nature of the human presence and amplifies the need to be individually responsible for the footprints that you leave. Since we are strangers for now, it seems only fair for me to allow you to weigh your views of my comments by what you may not see. In case you happen to be reading these remarks or listening to them on a podcast somehow, I'm a woodman of a certain age. I'm Jewish, and I grew up in a completely multicultural community. I grew up in that place you just saw. When I was 6 and 7, all I wanted was to have a First Communion. because those dresses and those veils were so completely fabulous. And the idea of walking down the aisle of the glorious church in our neighborhood just seemed to me to be better than anything I could think of. At the same time, my Catholic friends who came to our house often could not understand how I was so lucky to have 8 nights of Hanukkah when Christmas was only for 1. Helen Hardin, a famous Pueblo artist, was a high school close friend of mine. And Navajos and Indians from nearby pueblos, regular and honored customers at my family's store. In New Mexico, we do not believe in tolerance. Instead, we celebrate the beautiful differences that each of us bring to the common table of humanity. I live in a place where you have no idea who somebody is from their dress or the outside of their house. And I am apparently that rare bird, a fiscally conservative Democrat. I believe in social justice, a government safety net, rights for people different from me, and I am a capitalist and proudly a globalist as well. All of that and my own life experience color my views, and so now you have an understanding of the filter through which my comments come. Each American lawyer takes an oath as she's sworn into the bar of her state. They are almost all similar to the oath I took in the tumultuous summer of 1967. In Santa Fe, New Mexico, founded in 1640, I raised my hand to promise this. I do solemnly swear I will support the Constitution of the United States and the Constitution of the State of New Mexico. I will maintain the respect due courts of justice and judicial officers. I will not counsel or maintain any suit or proceeding which shall appear to me to be unjust, nor any defense except such as I honestly believe to be honestly debatable under the law of the land. I will maintain civility. I will maintain civility. It's interesting that I swear to do that as a lawyer at all times. Abstain from all offensive personality and advance no fact prejudicial to the honor or reputation of a party or witness unless required by the justice of the cause with which I am charged. I will never reject from any consideration personal to myself the cause of the defenseless or oppressed, or delay any person's cause for lucre or malice. This I do solemnly swear, and I did. This oath is in return for the enormous privilege and rights given American lawyers, including the right to keep their clients' confidences, the right to represent clients both in litigation and in the business of the day. And right from the start of my nation's history, American lawyers have done just that. The words "all men are created equal" actually comes from the Constitution of the colony of Massachusetts, drafted by John Adams and others. And in the 1700s, shockingly to me, I just discovered this in doing research for this talk, there was slavery in Massachusetts. And a lawyer for a runaway slave managed to persuade a Boston lawyer to represent him in the Supreme Court of Massachusetts on the question of if all men are created equal, what about him? And the Supreme Court of Massachusetts then, that long ago, held that the color of one's skin did not give license to another man to own him nor to mistreat him. John Adams, famously and importantly, was called to defend British soldiers who were arrested and charged with murder when they shot at colonists during a riotous demonstration in Boston as the Revolutionary War bubbled into a boil. What is most important to me in the context of today's American society is that even when Adams won acquittal for the British soldiers, he was not drummed out of the revolutionary movement, nor its leadership for representing the enemy in court. Can you imagine today how likely it is to have a Republican lawyer who takes a case against the government, say on abortion rights or civil rights or immigration, being appointed by the party in power as a judge or to any other government position? And I also wonder, to be fair about it, how likely a lawyer who represents a client or organization against abortion rights or in certain areas of religious freedom will have chances of having a Democratic government appoint her. Many of the founding fathers were lawyers. And there is no doubt that John Adams' work in drafting the Constitution was much on everyone's mind during the Constitutional Convention in Philadelphia in 1787. Adams was there only through his letters, as he was at the time ambassador to Great Britain. But this slender volume, okay, this is our Constitution, this is it, just these few miraculous pages. This slender volume, 1/3 is given to the invention of the presidency of the United States and the executive branch, 1/3 to the definition and powers of the Congress, and in Article 3, 1/3 to the new federal court system. The drafters, whether they were lawyers or not, understood very well that the new government and its diverse citizens would descend into chaos without powerful, independent judges who could decide in the courts the differences between them. The struggle not only to keep the republic, but make its aspirational words true, is what every American lawyer has taken an oath to do. 143 years later, after the adoption of the 12th, 13th, and 14th Amendments, the United States Supreme Court apparently struggled a little bit with Brown versus Board of Education, which addressed the separate but equal doctrine that allowed for racially segregated public schools, until, under the leadership of the Chief Justice, they could come to a unanimous opinion holding that practice unconstitutional. Giants of the legal profession like Thurgood Marshall and William Coleman and many other lawyers, black and white, in supporting roles, rightly believed that while demonstrating in the streets and in segregated facilities was important, the key to solving the harms caused by the separate but equal doctrine and the vast number of laws that made, for example, voting difficult in many areas of accommodation in the lives of black citizens of America, if not impossible, was found in the words of the Constitution and in the amendments. They believed that the courts were the place that would require the mechanisms of the federal government to act. The Civil War had produced the 12th, 13th, 14th, and 15th Amendments, but those dead set against equality for their fellow Americans who happened to be black had prevailed in almost every way to perpetuate racial discrimination in all forms. In the summer of 1966, Martin Luther King came to Chicago to lead the black community and their supporters in organizing both voter registration and resistance to institutional racism that had in Chicago many faces under the administration of the original Mayor Daley. Dr. King brought with him the Reverend James Orange and a number of young black men who were activists in the movement in Atlanta. That summer, I had an internship with the American Civil Liberties Union. Not in fairness, I must tell you, because of my commitment to the cause, although I agreed with all of it, but because it was the only place I could find that would hire a woman. I came into the office one morning when everyone else, including almost all of the lawyers in the city who were volunteers for the ACLU, were gone to a national convention. On my desk was a terrifying note. I was instructed to go to a police court in Chicago where a number of the young men that Dr. King and Reverend Orange had brought to help organize voting registration had been taken after being arrested for loitering and other petty charges, and the note instructed me to get them out of jail and go to court. There was only one problem. I had never been to court, and I had no idea how to get them out of jail. After finally finding one lawyer on his way to court himself who gave me the barest instructions, I took a taxi and after a great struggle got the court clerk to allow me to see my clients, there were 5 of them, who upon seeing me were clear that they might for the first time in history be given the death penalty for loitering. They were vastly relieved when I was finally able to persuade the judge to let them out without bail. But I had used my last $5 in pursuit of this great cause and had to borrow $5 from my client to get back to the office. Now, I knew that borrowing money from your clients was not something that lawyers were supposed to do. And I intently promised to meet them the very next day, actually the very next night, to repay my debt. They gave me an address on the south side of Chicago, and when I got to this very small three-floor apartment building, I could hardly get into the door of the first floor. But I elbowed my way up. I found my clients, and I heard a voice in the kitchen that no one would mistake. Dr. Martin Luther King sat in the kitchen of this small apartment, listening intently. Maybe his particular genius was his ability to listen, feel, and then speak and act. After hearing many horrible stories of discrimination and hatred, he said, "Listen, we have lawyers on our side. And the United States Constitution is on our side. And the Supreme Court will hear us. We have lawyers." And they did. And the Supreme Court listened to case after case of deep discrimination and responded. And as I mentioned earlier, the Congress, led, harassed, threatened, and bullied by Lyndon Johnson, passed a variety of civil rights legislation that gave civil rights lawyers additional statutory weapons so that everything didn't have to be a constitutional case. Thurgood Marshall, after defying all odds to beat back segregation in the courts himself, became a living symbol of what lawyers are supposed to be as he took his seat on the very highest court in the land, the United States Supreme Court. And for the rights of women, another lawyer came forward, Ruth Bader Ginsburg. As a justice of the United States Supreme Court, she has become an icon of courage, independence, and the model of a brilliant legal mind. But don't forget for 1 minute that virtually on her own, she came up with the legal arguments, some brilliantly using male clients, that pointed out the illegality and the impact of discrimination against women. Though she refutes this, the fact is she was a one-woman edition of the NAACP Legal Defense Fund. She argued 6 cases in front of the United States Supreme Court, winning 5 of them on behalf of the rights of women. She continues to write all manner of opinions, breathtaking in their intelligence, sometimes in the majority, as in the Virginia military case, and too often for me in the minority these last days, on the side not just of women, but many who are discriminated against, including in the recent North Dakota voting rights case, in dissent on the voting rights of Native Americans who live on the reservations in North Dakota, and we will see the impact on the election in North Dakota today. When I have moments of despair about the state of things in my country, I am buoyed when I see the outpouring of respect and affection that meets her at every step of her public life. This summer, each night that she walked into the Santa Fe Opera, as she quietly walked to her seat, the entire audience of 2,000 people stood and applauded her until she was seated and beyond. And to his credit, one of those nights, I noticed a deeply conservative, very famous Republican joined in standing for her as she came to her seat, and I thought, there may be hope. My view is that every lawyer who has taken the oath must be held to account to live up to it, as did Justice Marshall and Justice Ginsburg. I am overwhelmed with pride when I see individual American lawyers that you have never heard of, and law firms big and small, who take this oath seriously. And I am equally deeply troubled when I see lawyers, especially in public life, violate their oaths. In 2017, President Trump precipitously created a ban on people coming into the United States from Muslim nations that applied to people flying in planes at that moment coming into our country. As the impact of the ban became known, lawyers flooded international airports from New York to Los Angeles, from Seattle to Miami, bringing their laptops and portable printers, instructing colleagues at their offices to approach federal judges on a case-by-case basis, and in filing lawsuits requesting that the ban be subject to a temporary restraining order so that the constitutionality of that ban could be litigated. No one paid these lawyers. They just came as a kind of flash mob for justice. Their sense of personal responsibility was so strong, and their oaths moved them to act immediately. And the independent judges of the federal courts heard, acted, and the ban wended its way up to the United States Supreme Court. Even more recently, there has been a disastrous and evil family separation policy directed by President Trump, which was carried out at the border. What this meant in practice is that as families came across the border from Mexico into the various entry points in the U.S., when they declared themselves asylum seekers, hoping to be registered, has gone on for decades, and given a hearing to see if they had a credible fear that merited asylum in the U.S., they were instead forcibly separated from their children and adults from one another, with virtually no system in place to connect the children back to their parents or the caregivers who had brought them. And some of the parents had been given papers to sign in English, which they did not speak, giving up their rights. Law firms, individual lawyers, and my own lawyer daughter sprung into action, trying at the same time to stop the family separations and to get first bail and then asylum hearings for the families. I want to give you one insight into how difficult this is because it shows the real commitment of American lawyers and American law firms to justice. There are some good things about the internet. Virtually overnight, across the country, a group of internet moms was formed, including my daughter, who decided they would try to help. One family, I will not give the details to protect them, a father, mother, and a young daughter came across the border because the husband's sibling is an American citizen, and that person would be their sponsor. This family was assigned to my daughter. The father was sent to one location, the mother to an entirely different state, and their young daughter taken to a holding facility in yet a third state. Imagine any young child you know, virtually ripped from the arms of her parents, put on a bus and sent to a completely strange holding facility and speaking no English. Happily, my courageous lawyer daughter is bilingual in Spanish and was able to get the story of why they left their country. The thugs that ran their village were upset at something that the mother had done, and they broke into their house, beat the father, raped the mother in front of the child, and said they were coming back the next day. No surprise, under cover of night, they gathered what few belongings they had and walked toward freedom, toward America, toward where their family member was waiting to take them. They had no idea what was about to happen to them. With my daughter's relentless leadership, we found 3 different lawyers to represent them, obtain bail for the mother and father, and get the release of their daughter finally into their arms. This took place in 3 different states. A major American law firm sent lawyers and support staff to the border helping to build the case for asylum. And the American Bar Association put together immediately an entire group of people to help all of the families that they could find. And someone else on the internet put together funding for bail and expenses for the families, so devastatingly and I believe unconstitutionally treated by an arm of the U.S. government. Lawyers came from far and near to represent these individuals and to bring lawsuits in the federal courts on constitutional grounds, first stopping the policy and then working to take care that the children were being cared for and then reunited with their parents. This is no small task because of the way they were taken with no records and because some of the parents had been deported. This horrible chapter of American life is not yet closed, but American lawyers fight on. But I should tell you, it's not only major figures and major events like this in American history who call on lawyers to live up to their oaths, nor is every tale of obtaining rights well known. I tell law students often a story about how important it is to admire the courage of our clients. In the 1970s, there was a very famous young golfer from a small town in New Mexico whose name was Nancy Lopez. Nancy was the Tiger Wood of young women golfers, and at an early age was a national golf champion. Her parents were of modest means, and at the time, playing nationally ranked golf, even for a junior, was very expensive. They looked forward to the time when she could join the golf team of her public high school, and the golf coach could hardly wait to get her. At that time, there were no women's sports in high school, so the golf team was for boys. When word got to the powers that govern sport in New Mexico that Nancy was going to play on her high school boys team, they immediately reacted by telling the principal of the high school that if he allowed a girl to play on a boys team, all extracurricular activities, all sports would be stopped for that high school. In searching for help, Mr. and Mrs. Lopez ended up in the American Civil Liberties Union, and they found me. I agreed to take the case with trepidation, not only because I am the world's worst athlete, it's historically true, but because there were no laws that explicitly gave young women any rights to play sports or any other extracurricular activity in American public schools. Because I wanted to get into federal court if I could, I came up with the theory that the real discrimination was against the tax-paying parents of these girls. I figured I could last at least a day in federal court. But I explained to the Lopez family that our chances were, as we say in America, slim to none. Nonetheless, I had to exhaust administrative remedies, and in the process before our major hearing, the lawyer for the state school board called me to offer a settlement. By then, we had been joined by a number of other New Mexico lawyers representing girls who played tennis. The settlement offer was that they would change the rules so that any girl who was a national champion in a sport could play on a boys' team if there was no girls' team. I was so relieved that I flew down to Roswell to explain to the Lopez family this settlement which would let Nancy play. After my explanation, Mrs. Lopez asked me a question. Would all the girls who played tennis be able to play? No, I explained, none of them were national champions. Only Nancy would be able to play. Without hesitation, Mrs. Lopez said, Roberta, like this, Roberta, get back on that plane and don't come back to talk to us until all the girls can play. With no guarantee that her own child would prevail, Mrs. Lopez cared more for all the other girls and so instructed her uncourageous lawyer. Happily, we did prevail, and shortly afterwards, the laws required that young women get the same opportunities in sports as young men. All of these stories, writ large and small, speak to the dedication of many American lawyers to their oaths and to the courage of the citizens who rely on them. But to my sorrow, I see other lawyers, some of whom sit in the United States Congress, who have forgotten all or parts of the oath they took when they came to the bar. I see U.S. government officials, from the president through ranks of the executive branch, who seem to have forgotten what it means when they swear to defend and protect the Constitution. When the President of the United States attacks the independent justice system that he has taken an oath to protect, one wonders what are individual lawyers to do. When lawyers in the United States Congress attack the independence of the Department of Justice, undermine law enforcement agencies of all kinds, or blatantly fail to be the check and balance that is the keystone of our constitutional system, perhaps they need to reread the oath that they took not once but twice. Today, there are no excuses. No lawyer can stand aside or ignore what's happening. Tonight, before I know the outcome of the election in my country, or what will come from the investigations and lawsuits about foreign interference in our election process and litigation about the limitations of presidential power on the one hand and voter suppression on the other, I wish to make the point that one cannot simply blame others. Each lawyer must speak up when wrong is in front of her. I believe that lawyers who work for the government must decide when they are required to make a kind of noisy withdrawal, as though they were inside counsel of a corporation and detected wrongdoing by management or boards. Former U.S. Assistant Attorney General Sally Yates' courageous behavior provides the template that I think ethical lawyers in government must follow when confronted with illegal or unconstitutional acts. Invest the alleged action, communicate with those above you, and then, if necessary, publicly report what you have found. Lawyers in government work for the people who pay them and not alone for the president who appointed them. And as to Congress, I call on each lawyer there to recommit to their oaths, even though it may mean they may lose their seats or face criticism from their fellows. Courage of lawyers and integrity of judges and of public servants is what the founding fathers knew was a necessity to keep the republic they fought and died for. It is we the people, working together for the prosperity, happiness, and future of all of us that is our focus. Brave and principled lawyers and committed and independent judges putting their own views, political or religious, aside, must, as Dr. King said, stand up, act, and put Franklin's concern to rest. Lawyers must ensure that we keep our republic. I think the world depends on it. As I said a little bit ago, human presence where I live seems very small in the vast sky of my home. Especially we lawyers must leave only footprints that protect and honor us, each and all. Thank you.
Roberta, thank you for that wonderful talk. I'm going to keep my questions short because most of the people in this room know a lot more about law than I do. But I have to ask you, when you went to pay back your $5 and you found Dr. King in the room, how much money had he borrowed from them?
I think none. He was a very careful person about money because he had a whole movement to take care of, which is why it turns out, as you know, in a serious way, he lived so modestly and unfortunately came to an end because he traveled modestly as well.
Indeed. You mentioned that when you went to law school, lawyers were working miracles, civil rights and so on. And then you later talked about how today lawyers got very involved in become very involved in the whole immigration issue that we're facing. What other miracles do you see? What other causes do you see that lawyers are giving themselves to today?
You know, that's the best question you could ask me because those of you who have spent any time in the United States at all will know that American lawyers are the backbone of our civic life. There is not a nonprofit organization that doesn't have a lawyer for free, that put them together, works to make things possible. And so we always think of the big, flashy, important things. But in fact, most American lawyers have an obligation from their state bar to do pro bono work. That's free work. And in fact, we are all, whether we are litigators or not, officers of the court. So the court can also say to us, we have a backlog of a certain kind of case, and even though you don't do it, you have to do it. When I first started practicing, the district attorney and the judges were very excited to see a woman in Albuquerque in practice, and I was working for a law firm, and probably the first 6 months of my life, they appointed me to represent every indigent female criminal in all of my county, to the point that the managing partner finally called the chief judge and said, she's done not one billable hour. Do you think you might possibly find somebody else to do some of this work? So American lawyers really are very influential in every way.
Any other big causes that you see out there that merit?
Well, I think, for example, something that has happened, I think to the astonishment of some and the dismay of a few, is gay marriage. Mm-hmm. Really, many people, in fact, a wonderful woman, Margaret Marshall, was the Chief Justice of the Massachusetts Supreme Court who wrote the first gay marriage opinion. And I think that's been very important in our country. And I think, amazingly enough, even though there are people who have significant religious problems with it, I think the fact that the sanctity of marriage and what it means has been given to so many gay couples that everybody can see in their schools and all around them, that it's really, I think, changed things much for the better in lots of ways. So that would be another reason. And civil rights goes on. I mean, mm-hmm. Election law. Today, I can promise you, in every place, there are lawyers for Democrats and lawyers for Republicans, some of them being paid and most of them not, watching the election process to make sure that it works. Mm-hmm. In fact, when my wonderful husband was earning, I think, $200 a year as an intern, and our rent was $119, so things were a little tight, somebody came to the University of Chicago Law School and offered $50 to be a poll watcher on the south side of Chicago, which was like, I couldn't even believe this happened. So I was a Republican poll watcher on the south side of Chicago, and I then saw the importance of lawyers all around coming to make sure that the process was going to work.
Delighted to hear they watched the polls on the south side of Chicago.
Yeah, I know. I was a little surprised myself, but I took the $50.
Can we make a big leap to the Supreme Court?
Sure.
The process of the appointment of Brett Kavanaugh was very divisive in our country. I'm not going to ask you to predict how he will rule. He has to speak for himself. But just that process. Tell me your thoughts about that, if you could.
Well, it was ugly. There's no doubt about it. Years ago, before this happened, a very smart guy who's the president of Princeton now, named Chris Eisgruber, wrote a book about how bad the process was, and that was sort of post-Bork, but before a number of these things happened. I think that part of what has happened is that the Senate, which everybody thought was the greatest deliberative body in the world for many years, has broken down. Mm-hmm. And the kind of partisanship, and there's some on both sides, has made every single thing impossible. And as Senator Graham, an unfortunate rant, pointed out, he had voted for both Elena Kagan, which he did, and Sonia Sotomayor, which he did, and there are a number of Democrats who voted for Justice Kennedy and many other people. I personally think that there's a lot of things wrong with the process. I was very sad to see the American Bar Association. So in the United States, really for a very long time, starting with President Eisenhower, a Republican, was asked to put together a group who would vet federal judges secretly, and they did. And part of the reason for that was not to embarrass people, so that if there was something in their past that you've had, and also it turned out to be for many years very useful to senators, because somebody's brother-in-law would, they'd say, we really need you to support him to be a judge, and the ABA would find out that, he wasn't a stellar character, and they could then go to the senator and he could say to his brother-in-law, look, I would do that, but you'll never get past the ABA. But nobody knew, so there was no embarrassment by anyone. And that broke down when Judge Bork was nominated to the Supreme Court. And unfortunately, for this first time in ABA history, although I'm not sure this would have made a difference, instead of finding him, so the ABA committee has three things they can say: unqualified, qualified, or very well qualified. And even though Bork was a very smart guy, they found him only qualified, not well qualified. And do you want some water? I'm very sympathetic.
Thank you. You're welcome.
Usually that happens in New Mexico. It's so dry. I think it's because it's hot. And there were these series of hearings just raking the ABA over the coals. I spent days of my life, it happened to be when I was president and past president of the ABA, in front of the Senate. They asked us, they were sure that all Democrats were on the committee. We'd never asked anybody what their parties were when we appointed very distinguished people. And to my delight, when I had to call people and say, I'm embarrassed to ask you this, but I have to go to the Congress and I'm trying to report, they were almost all Republicans. But I think that was the beginning of it. And I think abortion right has a lot to do with it. Yep. So the Federalist Society and very religious people who honestly believe that abortion is a terrible thing recognized after Roe v. Wade that what they had to do was try to work to change who was on the court, and they have done that very successfully. This last thing was bad. I'll say a positive thing about it, where we are now in a second. One of the things I think is bad is that we have too many people who have just been judges on the court. So a good example to me is Sandra Day OConnor was a wonderful judge. She was a Republican. I disagreed with many of her opinions. I read them all once when I had to interview her and found her what a wonderful politician she was in her writing, by the way. And but she understood real life, okay? She'd been discriminated against as a woman. She had worked in practice. She was the minority leader in the legislature in Arizona, and she'd been a trial judge for about 20 minutes before Ronald Reagan found her and appointed her to the bench. She knew life in a different way. And when you have these people who have never done anything but be judges and practice United States Supreme Court advocacy, I think they have a very narrow view of the world. So I'm hopeful that part of what will change over time is that we'll go back to the broader view. Remember the Warren Court, which was so important in the civil rights era, he was a governor.
Yeah.
And became, I think, Chief Justice to the shock of the president who promised him, I think, that he would be appointed to the next Supreme Court opening if he supported Eisenhower. I think that was right. And the next Supreme Court opening happened to be the Chief Justice, and Warren called and said, okay. And Eisenhower said, no, I never said, but he ended up. And obviously his political skills were hugely important.
Let me ask you one final question, then I'll open it up. And again, I'm interested in the process, not the results, because I'm interested in the Robert Mueller inquiry. So whatever that comes out, we'll see. But does this now mean that every new president is going to now face automatically an inquiry if the Congress is in the other party? And because lawyers are big into precedent. Are we sort of seeing precedent sort of?
I mean, I hope that's not true. I mean, you have to admit, I think even some Republicans would quietly admit that interference in the election of a foreign government is quite an extraordinary thing in any country, and terrifying in a lot of ways. And so I think even at the beginning, many Republicans felt that this was absolutely necessary, and Mueller is obviously a Republican. So I am hoping that's not the case.
Who has smarter questions than me? Sir.
Yes, I'm Barak Campbell, professor of modern history at the Free University of Berlin, currently working on the internment of so-called civilian enemy aliens in the two world wars. And of course, and this is my point of departure, there has been a long tradition of xenophobia in the United States, as we all know. I mean, Sarah Churchill has just written and published a fascinating book on the ideology of America First. And if you look at the internment of so-called civilian enemy aliens in the two world wars, this has not left jurisdiction and judges untouched, of course. Some of these Japanese internees, for instance, in the Second World War, appealed to courts and even to the Supreme Court. And the Supreme Court confirmed this internment, which was not based on due process, so not on the rule of law, if you like. So what do I want to say and ask? My question relates to the question of the relationship between political power and political rule and justice and jurisdiction, on the other hand. What are your thoughts on this? I mean, of course, I mean, there are maybe good reasons for a fairly close relationship between jurisdiction and judges on the one hand and political power on the other. And irrespective of your views on that, of course, it's unavoidable because law does not exist in a political vacuum. But how can we protect law from political interference? Because on the other hand, of course, we need a kind of autonomy or semi-autonomy of the law, of course, and jurisdiction. So what are your thoughts on this? Because this seems to be a very current issue, but let me finally, thanks for a very fascinating, very interesting, and engaging, and to some extent very personal talk.
So I'm not an expert in any of these areas, but let me tell you about the Korematsu case. First of all, there's nothing that can protect the country from judges of the United States Supreme Court making terrible decisions. And we have had some terrible decisions, over the years, going back a very long way. Dred Scott was a terrible decision. There are, 5 or 10 decisions that everybody would point to as being truly horrible decisions. And one of the worst is the Korematsu case. So the Korematsu case is just the case that this gentleman mentioned, in which Fred Korematsu, a Japanese citizen of the United States, was with his family, along with virtually all other Japanese Americans, taken from their homes, taken from their possessions, and put in these internment camps. It was horrible. And that was a terrible mistake. I'm not so sure, honestly, I don't know the history of the case at all. I'm sure there are many people that do, some probably in this audience, that it was direct political power that had anything to do with the case as much as the national terror of World War II going on, which again you would hope would not be the case. Many people have apologized for the Korematsu case for many years, and I believe that it was President Obama who gave Fred Korematsu the National Medal of Freedom, and Korematsu died just a few days, I think, before a decision about the ultimate Muslim ban. I think that was the case in which the court apologized for the Korematsu case. So I don't think there is anything. This is why we have to be so careful that we appoint such brave and independent people to our federal courts.
Who else has a question?
I've sent them all into a coma.
We'll bring a microphone to you. Thank you.
I would have a question. You mentioned the severe impact the Supreme Court has and will continue to have on U.S. society. And you described it, at least in general, as a good thing that lawyers have such strong influence. It can turn into the other direction, of course. You mentioned that there were terrible judgments by the Supreme Court. Now I think there was this struggle about the appointments, and one of the major issues, I understand, is the right of abortion. So if the new Supreme Court ultimately says, no, there's no constitutional right, the states may find their own rules, prohibit abortion, then it would be in your logic, of course, that this decision has to be respected as all other decisions taken on civil rights and all the good things, to put it that way. And my question is there a substantial downside taking into account that these justices are appointed for lifetime, for some good reasons, but they sit there for ages, if they are appointed at the age of 45 or 50 or something like that, while as a citizen I can elect a new government every 4 years, and perhaps the influence of the justices is even more substantial than the influence of any of these governments. So is there a downside in giving so much power to the justices?
Well, that's our Constitution. And and certainly there are bad decisions, and there will be bad decisions, and I will be surprised, sad but surprised, if the rights of women to control their own bodies in a variety of ways don't find narrowing over time. I will be a little surprised, but I've been surprised in my life, if Roe v. Wade is directly overturned. But there are many other ways to make it virtually impossible for a woman to terminate a pregnancy besides absolutely outlawing abortion. Many people in the country have raised your point and wonder if we shouldn't have either an age of retirement, which they do in many countries, including Great Britain. A lot of our jurisprudence, as you know, comes from the English history. And I think in Great Britain, whenever you're appointed, you have to retire at age 70, I think, from what is now their Supreme Court. I am in favor, however, I'm conservative on this side. I'm in favor of lifetime appointment, in part because I think if you appoint someone so young and you say they're only there for 20 years, you risk that they will make decisions in order to then go on to a career later, because Supreme Court justices don't make very much money, and that would pollute their views more than that. So while there is a downside, my personal view is that it's much better to have lifetime appointments. I'll tell you what you should look at, which you'll find interesting. One of the benefits of the internet. I happen to know this because I was there on October 13th. Shortly after the Kavanaugh hearing, I was in Minneapolis when a friend of mine, the former dean of the University of Minnesota Law School, had a year ago invited the Chief Justice of the United States Supreme Court to come to Minnesota and to the university to be interviewed, just like this. You get me? He got this Chief Justice of the United States Supreme Court. You can do better, Terry. And
We're very happy where we are.
And this was literally days after the Chief Justice had been sworn in. And I want to call to your attention that both Justice Ginsburg and I think Justice Sotomayor went to the White House for that swearing in. And the other justices would have been there, but many of them were literally out of town. I mean, it happened just suddenly, and they were not somewhere to be found. Before the interview, Justice Roberts stood at the podium over there instead of coming to sit, as we all expected him to do. And this is online, and that's why I tell you the date. October 13th, University of Minnesota Law School, the Stein Lecture. And he said, I will say this inartfully, and he said it perfectly, I feel that I can't begin without addressing the events of the last few weeks. And he said, in short, we are a court for all of the people, and that is how we will behave. And when we come to the court, we put aside our political views and behave as justices for all of the people. Now, you can have your concerns about whether that is true or not. Often, even when I disagree extremely with decisions of the court, I think they are not political. I think they come from a very different view of the Constitution and life than I have. But remember also, Justice Roberts, I believe, understands very well that just as there was the Warren Court, this is the Roberts Court. And I will be very surprised if he isn't a moderating influence. I'm not saying a moderate, a moderating influence on the court in many ways, as he was in the Affordable Care Act case, in which, although he came about it in a way that I still don't totally understand, and I keep trying to read the opinion again, he voted that it was constitutional to keep the Affordable Care Act in the form that it was. So I have that hope, and I'll tell you one other quick story before we all leave. There are just the 9 of them, and nobody else understands their close relationship. And there have been courts that hated each other, but that has not been the tradition in the Supreme Court for the last 20 years. And the best example for people to understand is the relationship between Justice Ginsburg and Justice Scalia. You could not, I was lucky enough to know them both, you could not imagine 2 more different people in every possible way, except for their deep love and knowledge of opera. They literally agree on nothing else. This is Justice Ginsburg's story to tell, but I don't think she would mind in my situation here, my repeating it to you. And she did it when I interviewed her shortly after Justice Scalia's death, and she wanted to spend some time honoring him. There was a very important case called the Virginia Military Institute case. The Virginia Military Institute is a public institution, a public college in Virginia that did not allow women there. It was sort of like, you know what West Point is. It was sort of a statewide West Point. And a young woman wanted to go and brought a case, and it made its way up to the Supreme Court. And Justice Ginsburg was able to find 5 votes to agree with her that it was a public institution and they had to have women. So on a Friday afternoon, they were going to announce the decision, she said, on Mondays. They often announce their decisions on Mondays. So she was writing for the majority opinion. And Justice Scalia comes into her office, as she tells the story, and says, Ruth, I thought you might want to read my dissent over the weekend. So she said she put the dissent in her briefcase. She was off to give a speech somewhere in like Albany, New York, got on the plane, opens her briefcase. She's a very studious person, as you all know, starts reading the dissent, and she said steam on the airplane starts coming out of her ears. Because if you've read any of Scalia's dissents, I think he's been here. He's was a very clever guy. I mean, it's not just that he was smart, but he wrote in very clever and very acerbic ways, and just said the worst possible things about her reasoning. So she immediately flew back and worked all day Sunday on her majority opinion, which had already been adopted, And she realized that Scalia had come to give her that opinion on Friday so she could sharpen her opinion before it was announced from the bench. So if you understand that, you have some hope that those 9 men and women, some of whom you would like, some of whom you would agree with, and also, you know, they don't. Justice Ginsburg, for example, is very often on the conservative side of business cases. I mean, they're all over the map on these things. But it gives me a little, more than a little hope that no matter who appointed them, at some point, people stop being the appointee of the president that appointed them and become, as Justice Roberts said, the justice for the people.
The gentleman here, question? You want to take a little more?
Thank you very much. Reinhard Müller, Frankfurter Allgemeine Zeitung. That was a right picture you painted, I think, but history shows that not only in Germany, lawyers and even judges, in doubt, I think, followed their personal career or put business first and not democracy. And I think nowadays it's not that different. Of course, law firms, big law firms, have their pro bono programs, but I think this is very often just for show. But in doubt, they would, again, put business first, and which, for example, legal advisor of government steps down because of a certain war the government conducted. I think these are very rare cases and not the rule. So I think even under democratic circumstances, this is not, lawyers seem to be, again, easy to instrumentalize by the power and by business, of course. And I think this is still true for many lawyers, and this is, again, it's the rule, not the exception.
I think it is the exception and not the rule. I think we don't know how many lawyers. So in our system, if you're appointed to represent a criminal, you have to represent that person. Okay, it's not your job to decide whether the person is guilty or innocent. You absolutely have to represent them if you've been appointed by the court to do that. On the civil side and in the government side, there is no such requirement. And I think we have no idea of the number of times that lawyers turn down business. That's why I read the oath so carefully, that lawyers turn down business because they don't think it's right. It doesn't smell right. I think you have no idea of the times inside corporations that lawyers who are inside counsel say to people, you can't do that. We don't know that. We only know when they didn't do it. And as to those people who didn't do it, shame on them, and they should be disbarred. And I will shun them personally.
Thank you. I'm not sure if I'm going to be able to find the right words to say what I want to say, but if I leave this building, this lovely building tonight, and I haven't said it, I will be very annoyed at myself. However, I also recognize that in saying it, I'm probably going to annoy a lot of people in this room, including yourself, Madame.
That's okay, I'm often annoyed.
Good, thank you.
You won't be the first.
What I want to say is actually quite simple. But in order for me to say it, I have to give it a preface. I have to make a declaration of sorts, an admission, a confession. I am not a Democrat. I do not believe in democracy. And one of the things that I have had to experience in life is to listen all my life to politicians who represent and defend democracy. And they use the phrase rule of law. And when I hear the phrase rule of law, I do a sort of a double take. I don't quite react the same way that I react when I hear the word equality or rights. When I hear those words, I say, hey, as somebody who has thought deeply about the alternatives to democracy and the other systems that exist within the trajectory of Western civilization, not to mention the China or Islam and those other movements, I I say, okay, there's arguments against equality, there's arguments against human rights, there's arguments that can be made, maybe not between you and I, because we have different worldviews, and I understand that. But when I hear the phrase rule of law, I say that's incorrect, because the alternatives to democracy also have rules of law. They come from a different source, a different ideological source.
So where's your question going? Can you get
my question is, it's not really a question, Terry. It is really a comment that I'm taking the advantage here of saying that when I hear the rule of law, I would like politicians and people like yourself who defend democracy to say, I'm defending democracy, which you have wonderfully done, and I am defending the democratic rule of law.
Well, let me tell you that I actually agree with you. I didn't use the term rule of law, and I didn't, and I'll tell you, and I will tell you why. Many years ago, this is particularly apt in Germany for me to say this, I think. Many years ago, I had the incredible lucky honor of having breakfast with Elie Wiesel.
Mm-hmm.
And just the two of us. And I was talking, at the time I was working on some things in China, and I was talking about the rule of law. And Elie Wiesel reached out to me like this, and he said, Roberta, the Nazis had the rule of law. And that's why I'm very careful usually not to use that term. We have a constitutional democracy and we have a republic, and the majority is not allowed under our Constitution and the Bill of Rights to override individual rights that are enumerated in every way. And in fact, I think we all need to be mindful now, as varying political movements around the world, not just in our country, have forgotten how important it is for us to understand that the rule of law can be law imposed by evil people and can be evil laws. And it's the process by which those laws are both brought to the fore and enacted. And the truth is, that's why I say personal responsibility. I don't know myself how any of those guards at the border of our country pulled a baby away from a parent. I don't know, because I haven't been in this situation. But I pray I would have said to myself, I'm not going to do this. And so what is required of citizens who care deeply about humanity and about each of us is that we have to hope that we will be the person that says, whatever is happening, I am not going to do that. And the reason I showed you that picture, and the reason that I talk about New Mexico, is a serious one. And that is because I live in a place that has been inhabited by thousands of years, by people of 18 different pueblos. They speak different languages. They were run roughshod, many of them, by President Andrew Jackson. They had their children taken away from them and sent to Indian schools where they were often abused in terrible ways. And because I grow up in a place where when I go to the grocery store, I go to the grocery store with everybody. And I understand and watch people interact with their children. And the essential humanity and the requirements to make rule of law just has to come from every citizen. And it means when you see that it is not just, you have an obligation to do something. I don't know that I have the courage personally to always do it, but I am very aware of my human obligation.
And I guess that's why we have... Anyone follow it up? Yes, none. We'll make this the last one, I think. It was powerful.
You mentioned in the beginning of your speech that you are now afraid
of your democracy. Although you are referring always to your constitution, and it seems, and I know that by myself because I have been quite a lot in the States, that the constitution is very strong. But we are now in a situation where I think sometimes, is it very strong enough that you can keep as a state of America the constitution and the democracy? In Germany, there was also a time when the Germans by themselves abandoned their constitution, and then there was no democracy anymore. And sometimes I'm worried, not only for Germany, but also for the states, that we once again will come in such a situation.
Well, I said the truth of my feelings, which is this is the most consequential election of my life. But even if it doesn't turn out the way I hope it will, I think there has been an awakening. This is a complicated answer to what you asked. What happened in the 60s and the 70s is that many young people looked at American society and found it racist, sexist, and unfair. And when we responded, which was the way a fluid country has to recognize that those things were true. What happened is that we threw out something that was very important in our country. And that is the idea that we had a well-educated group of voters. And this is a very serious problem. And so one of the things that happened, this is my personal view, this has, I have no statistics to back this up. My personal observation is that we got rid of civics, which was what we taught in the United States in public schools, which taught people the Constitution, American history, world history, and their obligations, not their rights, their obligations as American citizens. And we also, as in many countries, not just ours, have not done the hard work of teaching children empathy and critical thinking. And if you don't have a society in which the citizens are empathetic and have the ability to have critical thinking, you're in trouble. Happily, I believe that the vast majority of our country does not believe the things that you see are being enacted right now. People need to remember that Hillary Clinton, who lost for a variety of reasons, won the popular vote by over 3 million votes. And now there have been very interesting reports in the press. A very important part of support for some of the policies of President Trump has come from the Christian evangelical community. And now, suddenly, which I never completely understood, and as I said, in New Mexico, we grow up with each other, so I've spent many times in Methodist and Lutheran, Episcopalian, and Catholic churches, and I never understood why it was possible to be a good Christian and support some of these things. I mean, I say that as a Jew, but I never understood that. And now young people are suddenly saying to their parents in the evangelical movement, and these are our most committed Christians, we always ask the question, what would Jesus do? And I think they're coming up with a different answer. And that gives me hope as well. And when I see the response in my own community in Albuquerque and in Pittsburgh to the slaying of 11 Jews at their Shabbat prayers, when I see that the first person to call my rabbi in Albuquerque was the imam from the mosque, okay, and the people who came were young Muslims in our community, I say to myself, maybe it's not so bad. And maybe just like that very famous Republican who I didn't want to name because he would be ruined, who stood up to applaud Ruth Ginsburg, maybe there's hope.
Roberta, thank you so much.
Thank you.